Thank you very much. A very warm welcome to the second edition of the Praelium. Those of you who attended the inaugural edition last year will know why we use the tagline, a celebration of advocacy. Because advocacy is really all that this event is about. It's an opportunity to see two leading practitioners in our field in action and to see how it is done, or at least how it can be done. They will be making prepared oral submissions, but they will also be tested and challenged to think and respond on their feet by what is, by any measure, a rather intimidating tribunal. Our cast this year really doesn't require much by way of introduction. Our two advocates are Santens and Matt Geering. Ank is a partner in the International Arbitration Group at White & Case in New York. And Matt is a partner in the International Arbitration Group at Allen & Overy, based in Hong Kong. They've come from far, and we're absolutely delighted to have both of them with us today. Our tribunal this year, as I said, quite high-powered. Our co-arbitrators are Judge David Caron of the Iran U.S. Claims Tribunal and King's College, Professor George Bermann of Columbia Law School, and our president this year, I'm delighted to say, is Professor Gabrielle Kaufmann-Kohler of Levy Kaufmann-Kohler and the University of Geneva. You should all have received a document that sets out the case on the basis of which our advocates will be making their submissions. You will have seen it's quite detailed this year, and much of the credit for that goes to our advocates who spend a lot of time and effort contributing to that. If you haven't had a chance to read it, not to worry. It's like a Coen Brothers movie. Even if you don't get the plot, you can still enjoy it. So with that, Gabrielle, may I invite you to open the proceeding?
Thank you very much. Good afternoon to all of you. It is nice to see that transparency is gaining ground, and I'm pleased to open this hearing with all the public attending. We will hear oral argument. This is the final hearing in the case between now I need to get the names right. Dystopia is the respondent state, represented by Ms. Santens, and the claimant is Ethiopian Gas, represented by Mr. Geering. You have agreed on the order of the argument, I understand, and we will have the claimant, the investor, starting. You will have about 20 minutes. You can use a little bit more, but we will cut you off at some point. So, and we will, of course, maybe interrupt you with some questions as well. And then we'll see whether you need replies or not, or whether we simply have a discussion with the tribunal. Fine. Would you like to start? Any remarks before we start? Questions?
That's very clear on my side, Madam President. Thank you.
Fine. So you have the floor, please.
Thank you, Madam President. As you know, and as the members of the tribunal know, I appear here for the claimant, Utopian Gas. My friend, Ms. Santens, appears for Dystopia, the respondent state. Now, there is one question before you. It is a deceptively simple question, but the simplicity conceals some complexity. And the question is whether the tribunal lacks jurisdiction because the respondent says Utopian's investment in its investment vehicle, Matrix Gas, was tainted by bribery and corruption of public officials in Dystopia. Now, conscious of the seniority of the tribunal and having some experience of members of the tribunal, I won't bore you with a recitation of the facts because I trust that you will be very well read in. And on this rather unique occasion, I also note that you're assisted by some 100 tribunal secretaries who will be able to fill in any gaps in your factual knowledge. I'm going to deal with the law, and then I'm going to deal with the facts briefly. Let me introduce my comments on the law with this brief introduction. Those of you who were in the UK last week, and those of the tribunal secretaries who were in the UK last week, may have picked up a news piece where a TV crew picked up and reported a private conversation between the British Prime Minister and Her Majesty the Queen, during which the Prime Minister, David Cameron, said to Her Majesty, "We have got the leaders of some fantastically corrupt countries coming to Britain today, including Nigeria and Afghanistan." Those comments were intended to be private. Of course, they were reported, and a controversy has ensued about those comments. Interestingly, the President of Nigeria has publicly agreed with Mr. Cameron's sentiments. Why is that relevant here? Well, it's relevant here for the following reason. The essential problem with what I anticipate to be Ms. Santens' case, that corruption should be subject to something other than a very strict or high standard of proof, is that one starts to slide down a slippery slope. And it is a slippery slope which is born of sweeping generalizations and sweeping prejudices, arguably, such as those made by the Prime Minister. Namely, that one starts to slide or inch towards a situation where perhaps subconsciously one thinks, oh, well, dealings in that particular state are quite likely to be corrupt because everyone and everything is likely to be corrupt there. As soon as one starts to roll or slide down that slope, expressly or implicitly, the danger is that the burden of proof starts to reverse. The sentiment becomes, you, the investor, need to explain clearly how you, in this case, spent everything you did spend in the state, or your consultant spent everything it spent in the state. Otherwise, we will assume that you were up to no good. And that approach, if I may say with respect, risks gross unfairness. With that introduction, I have 5 points on the law. First is that, let me state this for the record, corruption is heinous, and corruption should be eradicated. It can cause huge long-term economic damage. And on our side, and on behalf of the claimants, we absolutely endorse all measures which are taken to eradicate, to identify and eradicate corruption. However, whilst tribunals should, of course, not be a soft touch for those involved in corrupt dealings, they should not swing the other way and make findings of corruption unless they are really sure that corruption has taken place. That's the first point. The second point, and it's unfortunate that I have to say this, but is that corruption allegations are increasingly the first recourse of a respondent state, a knee-jerk reaction, if I might say, to a claim. Too often, the allegation that the investment was tainted or procured by corruption is a hopeful defense to divert the tribunal's attention away from clear breaches of the substantive protections afforded by the relevant treaty. The state has no defense on the merits, so it hopefully casts about in the hope of seeking to find a corruption point in there somewhere. And sometimes in this context, indeed very often, corruption is raised by the state not in a focused way, but more in hope than in expectation. The hope of the state is that a train of inquiry might emerge, which may lead the tribunal to becoming suspicious of the activities of the investor. Now, of course, in all other areas of arbitration, fishing expeditions are discouraged. And I submit that what we are being faced with here is a fishing expedition. The third point is this: allegations of corruption have been made, it is reported, in about 25 investment cases, reported investment cases since 1996. One finds that in the article by Lamson and Anthony Sinclair, published in 2015. But there have only been 3 cases where a finding of corruption has actually been made in my submission. They are all different. The first is, of course, World Duty Free and Kenya, a case that will be well known to the tribunal, where the investor left a suitcase, a very blatant way, of $2 million in cash outside a room when the investor representative went in to meet the president of Kenya. When he came out, his suitcase was still there, the cash had gone, and the cash had been replaced, rather intriguingly, with fresh corn. That is a very different case, of course. That's a case of clear corruption, described by Constantine Partasides in his 2010 article in the ICSID Review as being not so much a smoking gun of corruption as a Technicolor video of the gun being fired. So that is the first case, doesn't assist you. The second case, somewhat closer to home, and I say that particularly with regard to Madam President, who of course sat on that, Metal Tech and Uzbekistan in 2013. That, of course, was a case in which involved a payment of some $4 million in consultancy fees, or fees of some sort, to a group that included the brother of the Prime Minister of Uzbekistan for services that could not be substantiated and were not found to be within the expertise of the group to whom they were paid. Now, on those facts, the tribunal was prepared to find corruption, notwithstanding the absence of direct evidence. Now, I accept that is the case which bears the closest resemblance to the fact pattern which we are dealing with here today. But I'll come back in a moment to tell you why you should not follow it. The third case, I said there were 3, the third case is a case called Nico and Bangladesh. Again, a case where the investor's bribe was obvious. The investor had bribed the relevant minister by buying the relevant minister a Toyota car during the contract negotiations. But this became known. This became publicly known. The minister was disgraced. He was resigned. The state, through another persona, then continued the negotiations. The agreement was concluded. The agreement included an ICSID arbitration clause. The tribunal in that case found there was no causal link between the unlawful gift and the investment itself. Now, in all of these 3 cases, the relevant evidence was uncontested. In all other cases, assuming Mr. Lamson and Mr. Sinclair are right, the other 22 cases, corruption has been dismissed or fallen by the wayside. Now, I said that the Metal Tech case was the closest case on the facts, but I said that you should not follow it, and this is why. There are 2 reasons. First of all, Metal Tech can be distinguished on the facts from the present case. But secondly, and one could reverse the order of these points, I don't emphasize one over the other. The tribunal, I may say with respect, went too far in being ready to infer a matter as serious as corruption on the rather unclear facts of this case. Now, I say this for two reasons. First of all, what the tribunal found in that case, and this comes out from paragraph 265 of the award, was that because the tribunal could not track down sufficient evidence of what the relevant consultancy services had been used for, the tribunal inferred in the circumstances that the payments, whether through the consultancy group or directly, were essentially bribes. Now, on the facts of that case, we say that even assuming that a tribunal finds that an explanation as to what was done under a consultancy agreement is unsatisfactory, absent any other clear factors pointing to illegality, it is with respect too big a leap, too big a jump to assume that the payments stated to be for consultancy services were in fact paid to public officials. It is with respect nothing more than conjecture. It's speculation that that is what happened to the funds, the $4 million US, which were paid to the consultants in the Metal Tech case. And secondly, this is an important point, even if one or more bribes were paid, Metal Tech, with respect, does not deal clearly with the causation question. This is because the fact of a bribe is not enough. The tribunal needs to find that the bribe procured the investment. The Nico and Bangladesh tribunal were well aware of that point. Unfortunately, the Metal Tech tribunal was not. So that is what I say about the three, it appears, the three cases where corruption has been found. My fourth point is to come to the crux, if you like, which is the applicable test or the burden of proof. And there are two subpoints. The first point, I think, is uncontroversial. Each party bears the burden of proving the facts on which it relies. So Ms. Santens, on behalf of Dystopia, bears the burden on this issue. The second is more tricky, and I accept that. What standard is to apply to the relevant facts? Now, I say, my submission is, that you should look for and apply the clear and convincing evidence test. I take that test from the award of the tribunal in EDF and Romania at paragraph 221. The two relevant sentences are as follows. The seriousness of the accusation of corruption in the present case, considering that it involves officials at the highest level of the Romanian government at the time, demands clear and convincing evidence. There is a general consensus amongst international tribunals, a general consensus, I emphasize that, amongst international tribunals and commentators regarding the need for a high standard of proof of corruption. Now, this high standard or clear and convincing evidence standard has been followed in quite a few cases. You have them in our submissions. I just list the most relevant ones here. The Contractual Tribunal in Westinghouse and the Republic of the Philippines, and the ICC Tribunal in 1998 in the Hill-Martin case. So let me be clear about what I say this means. The respondent state needs to show that bribes were paid by reference to the clear and convincing evidence standard, and let's not forget causation. It needs to show that the bribes procured the investment. Now, stepping back for a moment, why should you apply this test? Because none of these cases, and I think we both accept this, none of these cases actually bind you. They're persuasive, so why should you apply them? It's quite simply this. A finding of corruption has very serious consequences. Serious consequences which go well beyond an ordinary finding of breach or non-breach, an ordinary finding of a breach of contract or a breach of treaty. And one can think about the seriousness of those consequences. To find corruption, firstly, of course, usually in one sweep, invalidates the investor's entire investment. It is a golden bullet, if you like, which brings the whole claim crashing down. Secondly, the finding is likely to have serious knock-on consequences for the investor's other activities in other countries if they exist. Following an award which would find corruption, the investor is likely to be investigated by regulators, quite probably globally, looking for similar fact evidence of similarly allegedly corrupt behavior. It could quite easily get to a situation where the finding then effectively paralyzes the investor's business. Thirdly, the finding is likely, at the very least, to devastate the careers of the individuals involved. And fourthly, even more seriously, it may lead to criminal prosecutions, including, on occasions, imprisonment, especially if the relevant individuals find themselves subject to the jurisdiction of the host state. So it's a serious business, and that is why you need to approach it with caution. Now, my fifth and final point on the law is this. There is an alternative approach to the clear and convincing evidence test. And that is as follows. I don't advocate it, but I say even if you go down that road, you end up in the same place. And that is to formally apply a balance of probabilities test, but in so doing, to require more pervasive or cogent evidence. Now, one finds that alternative approach enunciated in several cases. Perhaps the best known, and forgive me for citing this as an English lawyer, is the decision of Lord Hoffmann in a case called Secretary of State versus Raymond in 2011. Now, it's a case, not an investment case. It was a case concerning the contested deportation of an individual with suspected links to terrorist organizations. But Lord Hoffmann said this in relevant part. The civil standard of proof always means more likely than not. The only higher degree of probability required by the law is the criminal standard. But, paraphrasing, some things are inherently more likely than others. It would need more cogent evidence to satisfy one that the creature seen walking in Regent's Park was more likely than not to have been a lioness than to be satisfied to the same standard of probability that it was an Alsatian. On this basis, cogent evidence is generally required to satisfy a civil tribunal that a person has been fraudulent or has behaved in some other reprehensible manner. But the question is always whether the tribunal thinks it's more probable than not. So what Lord Hoffmann is saying is, well, we still apply the balance of probabilities test, the usual test, but we need cogent, was his word, cogent evidence. The Libananco and Turkey Tribunal essentially went down the same route. They said, we don't accept there's a higher standard of proof, but allegations of corruption, or fraud or serious wrongdoing, they were actually dealing with, would require more persuasive evidence. Now, what I say about this is that even if you go down this route, it leads you to a very similar place to the clear and convincing proof standard. That is because whether you say the burden is, whether you say the standard, the initial standard is higher, i.e. one needs to get to the clear and convincing standard test, or you say it's balance of probabilities, but within that, essentially you need to exercise extreme caution because you're looking for more persuasive, to quote Libananco, or cogent, to quote Lord Hoffmann in Raymond, you get to the same situation. And this is because strong evidence is needed to prove something which is inherently improbable. Takes one back to Lord Hoffmann's example of an Alsatian or a lioness in Regent's Park. Now, and this echoes what I said at the start, what if a country has a general reputation for corruption? If the Prime Minister thinks it's corrupt, or because, for example, it's ranked by somebody like Transparency International as being particularly corrupt. Is this relevant? Well, if it is relevant, on this basis, an investment in somewhere like Denmark, which from my perusal this morning is top of the, it's top of the Transparency League of Clean Public Governance, an investment in Denmark would be very unlikely to be corrupt. But on the other hand, an investment in somewhere like Sudan, Afghanistan, or Somalia, all of whom are vying for the joint bottom place in the Transparency League table, one could assume on this basis that corrupt activities were much more likely to take place. Is that the right approach? No, I say it's not the right approach. It would be a very dangerous step, because to go down that road essentially brings, as perhaps the Prime Minister did the other day, brings one's prejudices into judging a situation which should just be judged on the facts which are available to you. So that is what I say, my fifth and final point. Whether you apply the clear and convincing evidence test from EDF and Romania or the cogent evidence approach from Lord Hoffmann, you get to the same position. Now, just briefly, part two, turning to the facts of this case. The allegation, of course, as you well know, is that Utopia's investment in Matrix was tainted by bribery and corruption of public officials, and hence wasn't made in accordance with the laws and regulations of dystopia. Now, with the greatest of respect to Ms. Santens, this allegation does not get off the ground. It does not, in fact, even reach the runway. There's no clear and convincing evidence. In fact, there's no evidence at all. I said earlier, Metal Tech is the closest reported case to the current facts. I said Metal Tech, with respect, had been wrongly decided, but even if you think it's been correctly decided, as I suspect you may, there are obvious differences between the facts of the two cases, particularly threefold. Firstly, in Metal Tech, the claimant in that case originally said, the claimant in that case was very unclear, put it this way, about what the consultants were intended to do. Initially, they said they were there to provide technical support for the project. Only at the hearing did they change tack and say they were actually lobbyists with no experience of the sector. That, one might say, is inherently suspicious. In the present case, firstly, Utopia has not been misleading. And secondly, it has fully complied with the Tribunal's disclosure order, procedural order number 3. It has opened its cabinet. It has opened its electronic records. It's disclosed the contract with its consultant, Panopticon. It's disclosed the 10-page letter setting out Panopticon's strategy, and it's disclosed some 50 emails between the CEO and the representative of the consultant. Secondly, in this case, Utopia...
I'm a little concerned when you start saying secondly, because I don't know how many further points will come, and you're already well over time. I think we need to have time also for questions, and obviously we want to hear your opponent. Can you briefly summarize the rest? I also see that you have many more pages, I get a little nervous.
With the indulgence of the Tribunal, I will aim to be another 2 to 3 minutes, if that's acceptable. The second point, very shortly, is that Utopian, in this case, engaged not a shadowy outfit, it engaged the leading consultancy firm in the state, Dystopia. And secondly, it did so in a country where we are expressly told, and it is common ground, that lobbying was legal. And thirdly, Utopia have produced an expert report from a Mr. Cicero. Now, Mr. Cicero is qualified to give expert evidence to you, as he is also a former prominent lobbyist in Dystopia. And Mr. Cicero's evidence is twofold. Firstly, he says that a services contract in this form is perfectly normal in the relevant state. And secondly, he says it is also perfectly normal for lobbyists to not provide detailed work reports or itemized receipts. So Mr. Cicero's view is that this contract, there's nothing suspicious about this contract, no red flags, it's all carried out in the ordinary course of business. Madam President, I have transgressed over time. Thank you for allowing me that. And I'll reply shortly if that becomes relevant later. Thank you.
Thank you. Do my co-arbitrators wish to ask questions from Claimant's counsel at this stage? Do you prefer hearing first Respondent?
I will ask one question.
Yeah, sure.
Likewise.
Yeah, sure.
Mr. Gehring, you didn't go to the relevant part of the treaty that's involved.
Yes.
Which is the objection rests on made in accordance with the laws and regulations
Yes.
of Dystopia. And if the violation in this case, not made in accordance, is that the contract was procured by bribery, are we, should this tribunal look at itself as placing itself as a court of Dystopia, trying to decide whether this contract is therefore void, if that's appropriate? And second, if that's the case, why isn't the standard of proof that which would be used in Dystopia?
That's correct in part, sir. You are to reach a view, I think this is common ground, as to whether or not the activities, and in this case the particular activity is the engagement of the consultant Panopticon, was in accordance with the laws of the host state. It's also common ground that if there was that bribery and corruption is contrary to the laws of the host state. I don't think you have to put yourself in the position of a court in Dystopia in order to do that, but you have to apply the relevant legal standards from Dystopia. Now, as regards your second question, normally, sir, if I may say, the question of burden of proof is a question which arises from the forum or the lex fori. And that is why I say to you, that it's appropriate, as previous tribunals have done, to be guided by the international jurisprudence on this question, rather than any competing dystopian law on burden of proof, to the extent that it exists.
Thank you.
I have a very narrow question to begin with. You didn't have a great deal of time to develop your presentation about the expert witness, Mr. Cicero.
Yes.
But just as a technical matter here, he was not available for cross-examination for any number of reasons that we haven't time to go into. But I would like to know what you think should be the role of his testimony before us as to expectations about conduct in Dystopia when he was not, for whatever reason, available for cross-examination, which I understand to be the case.
Yes.
And why don't I just ask you my second question, and you can reply in any order. This is more or less a question than a comment, actually, but pretend it's a question. If we are to entertain this inquiry into a balance of probabilities, this is your fallback position, which should determine the presence or absence of cogent proof based on the balance of probabilities. Can you explain to me how we could sensibly do that while still disregarding the culture of the country in question? You say we should not distinguish between Denmark and Sudan. That's a dangerous thing for us to embark upon. But please try to explain to me how we could sensibly conduct a balance of probabilities inquiry in that totally abstract situation we would be in, disregarding anything and everything having to do with the place in which the conduct will have occurred. Are you suggesting, in other words, to us, that the balance of probability of bribery and corruption is to be deemed to be the same in every country in the world?
Thank you, sir. Two questions, I think. The first is, yes, Mr. Cicero didn't appear. Now, he says he didn't appear because he says he feared for his life if he were to come before you. Now, generally in international arbitration, when a witness doesn't appear, it's a question of weight. His evidence, we're not in an English or any other court here, it's just a question of what weight you want to attach to that evidence. Now, we submit that he is a credible witness, that the reason he has given for non-appearance is genuine, and that his evidence that he has given stands for itself and can be appropriately analysed. If you have questions about it, you can ask us. But it is, we'd say, straightforward evidence which has the air of credibility, and therefore, in your balancing exercise, you should accord it significant weight. Your second question, sir, was about the fallback standard, Lord Hoffman's standard, the cogent evidence standard, and the Lioness and the Alsatian in Regent's Park. You said, so, you said, Mr. Gearing, you're asking me to look at this, and if my note's correct, you said totally in the abstract, and should I therefore say that Sudan and Denmark are the same? Well, with respect, sir, I'm not asking you to look at it totally in the abstract. I'm saying that you should definitely look at all the facts that you have. You should look at the fact that my client has a track record in investing in power projects around the world. You should look at the fact that it engaged the leading consultancy firm at the time. And you should also take cognizance of the fact that there's no actual evidence that anyone was actually paid anything, that any bribes were paid. So you must most definitely look carefully at all the facts which you have available to you. But if, and I don't think this submission is being made, but if, for example, this was the country which is bottom of the Transparency League table, should you be more inclined to find that a reputable investor had committed bribery? Not unless the facts support it, no.
Thank you.
I'm asking myself, and I'm asking you, of course, who has the burden of proving the legality of the investment? You are the claimant.
Yes.
You bring an arbitration. You must meet the requirements of the treaty. The treaty says you must be an investor. Was an investment made in accordance with the law of the host country. Now, are you bearing this burden, or does the respondent bear the burden of proving that you do not have an investment that is legal? How do you analyze this on the basis of the treaty?
We've set up our case. We've pleaded our case. We've set up our case. Ms. Santens makes a specific point and says the investment is not in accordance with the laws of the host state because it's procured by a bribe. When she makes that allegation, the burden is on her.
But you make the allegation that you have an investment in accordance with the law. Could one not say that you have the burden of proving that this allegation is correct?
Well, she can't simply, she doesn't with respect seek to do this, but one can't simply put up a general point and therefore say, well, the investor has to run around and prove the negative in every single case. The only way I submit it can sensibly work is Ms. Santens says, well, we have a specific point as to why this investment is in fact unlawful.
So you're saying there's a presumption of legality?
Well, I'm saying that once we've set up our case, I'm saying the burden, if Ms. Santens wants to disprove that on the legality point, or indeed any other point, the burden shifts to her.
Thank you. I suggest we now hear the respondent, and then we may have other questions, and possibly they may be addressed to you as well. And you can, of course, some of the questions you may be able to pick up as well. You have the floor now, please.
Thank you, Madam President. Is my microphone working? Yes? Thank you. Yes, I hear it now too. Distinguished members of the Tribunal, Claimant Utopian Gases claims against Respondent Dystopia must be dismissed for lack of jurisdiction. The Tribunal lacks jurisdiction over this dispute because Claimant engaged in bribery and corruption in making its investment in dystopia in violation of dystopian law. And as a result, Claimant's claims fall apart at the first article of the bid, Article 1.1, which provides that in order to qualify as an investment under the bid, investments must be made in accordance with the laws and regulations of the contracting party in whose territory the investment is made. Now, as I will address in my presentation, the totality of the evidence in this case compels a finding of corruption. Now, there's no direct evidence of corruption, as Mr. Geering has repeatedly stated. And of course, there hardly ever is. Corruption is intrinsically clandestine, and it is only in the rarest of cases, like World Duty Free versus Kenya, that a corrupt party will acknowledge its corruption or that there is other direct evidence of corruption. In most cases, there is a cluster of evidence. And my submission, members of the Tribunal today, is that in this case, the cluster of evidence, or the so-called faisceau d'indices, inexorably leads to the conclusion that the $5.2 million that Claimant paid to Mr. Porphyros and his firm Panopticon was used to bribe public officials in dystopia in order to obtain the matrix gas concession. And it is our submission that, like many other arbitral tribunals have done before you, and I will come back to this tribunal should find the circumstantial evidence in this case sufficiently persuasive to sustain a finding of corruption. Now, before I address the facts in more detail, I will address three legal points: the burden of proof, which has already been discussed, the standard of proof, and the propriety of making a finding of corruption on the basis of circumstantial evidence. Now, first, the burden of proof. Madam President has already addressed that there is potentially a question in this case as to which party the burden of proof lays on. But even if you find that the burden of proof here lies on the respondent would like to emphasize that in considering whether the burden of proof has been met, the tribunal has a duty to consider the totality of the evidence, what both parties bring to the evidentiary exchange, because the burden of proof is not necessarily a burden to produce evidence, it is a burden to persuade. As the Rome Patrol Tribunal put it, and I'm quoting, whether a proposition has in fact been proved by the party which bears the burden of proving it depends not just on its own evidence, but on the overall assessment of the accumulated evidence put forward by one or both parties for the proposition or against it. And as the Metal Tech Tribunal explained, in considering the totality of the evidence, the tribunal may also consider the absence of certain evidence. As that tribunal recalled, referring to the IBA rules of evidence, the tribunal may draw appropriate inferences from a party's non-production of evidence ordered to be produced. And that is not a shifting of the burden of proof or casting on the denying party a burden of disproof. It is simply what a consideration of the totality of the evidence requires. Now, turning to the standard of proof, I think it's worth emphasizing that as the Rome Patrol Tribunal highlighted, in international arbitration, including investment arbitration, the rules of evidence are neither rigid nor technical. The tribunal has great discretion and flexibility in weighting the evidence and determining whether an allegation has been proven. Indeed, in the Metaltech case, the leading case on corruption, the tribunal considered the debate about standards of proof an interesting one, but deemed it not necessarily to take a position on the standard of proof to resolve the dispute before it. Now, if you are minded to determine the applicable standard of proof in this case, Respondent submits that it should be a preponderance of the evidence or a balance of the probabilities. It is well established, and I think my colleague acknowledged it, that that is the generally applicable standard in investment arbitration. Now, my colleague also argued that for allegations of corruption, the standard should be higher. And as he pointed out to you, there is authority for that position. But there's also authority for the opposite position. For instance, each of the Fraport, Tokios Tokeles, and Lebananko versus Turkey tribunals considered and rejected the argument that they should apply a higher standard of proof to allegations of corruption and the like. But more important than a tally of precedent one way or the other are the policy reasons that should inform your decision as regards the applicable standards of proof in this case. Now, the authorities that favor a heightened standard of proof for allegations of corruption rely on essentially two policy reasons. First, it is suggested that the standard should be heightened because of the seriousness of the consequences of a finding of corruption. But what is at stake here is whether claimant's shareholding in Matrix Gas qualifies as an investment for purposes of the bid. And the most serious consequence of your finding of corruption is that claimant's claims will be dismissed. This tribunal is not a criminal court sending anybody to jail, and finding corruption is not necessarily more serious than finding unlawful expropriation or discriminatory treatment, which may also have serious reputational consequences, both for the state and for the individual officials involved in the acts that are found to amount to an unlawful expropriation or discriminatory treatment. Now, Mr. Geering submitted to you that finding corruption may lead to claimant's claims being dismissed. Yes, it may. And that is the standard to which both states, Dystopia and claimant's home state, Utopia, agreed in the bid. Now, it is also argued that the normal standard should be heightened because of the inherent unlikeliness of the presence of corruption. And there are two responses to that argument. First of all, corruption is not inherently unlikely. Many studies have shown that it is a pervasive problem affecting the lives of millions of people and involving trillions of dollars. In 2013, the president of the World Bank stated that in the developing world, corruption is public enemy number one. And second, and in any event, whether an allegation is likely or not should not affect the standard of proof applicable to it, but only the cogency or persuasiveness required of the evidence. And Mr. Geering referred you to Lord Hoffman's opinion I think he also pointed out that the Libananco Tribunal, for instance, adopted a similar standard. Now, Mr. Geering put to you that there really is no difference between requiring clear and convincing evidence and stating that the evidence must be more cogent or more persuasive. But I submit to you that there is in fact a very important difference. Stating that more cogent or more persuasive evidence is required is a descriptive statement of what it takes to persuade the tribunal. When I tell you that I saw a lioness in Regent Park, that is less likely than when I tell you that I saw an Alsatian in the park. So it will be more difficult to persuade you of the former allegation rather than the second, and more cogent or more persuasive evidence will be needed. But critically, that is true regardless of the standard of proof. By contrast, clear and convincing evidence, as described in the cases, is a heightened standard of proof, which can, if you will, also be described as much more likely than not, as opposed to simply more likely than not. And that is a prescriptive rule. And if one applies this higher standard to intrinsically less likely allegations, one adds a further layer of difficulty in proving such an allegation. The allegation is intrinsically difficult to prove, and now it's made even more difficult to prove because it must be shown to be much more likely rather than just more likely. Another way to think about it is in terms of the discretion granted to the tribunal. The standard of proof is an objective concept. It leaves less room for discretion than the weighing of the persuasiveness of the evidence, which is discretionary and a subjective undertaking on the part of the tribunal. Now, the fact that the clandestine nature of corruption makes it one of the hardest allegations to prove is in fact a critical factor against heightening the standard of proof, because raising the standard of proof for this intrinsically hard to prove allegation would make arbitration a safe haven for corruption. And that is in fact the point that Mr. Liamson, I hope I pronounced that correctly, and Mr. Sinclair make in the article referenced by my colleague. Their point is that it is because in an international investment arbitration until recently the evidentiary rules were applied too rigidly, a finding of corruption has been made only in very few cases, even though it is universally known that corruption is rampant. And they laud what they perceive as the beginning of a move away from the uniformity and rigidity of high standards of proof as a positive development, arguing that the unsatisfactory status quo would expose international arbitration to further criticism for being a soft touch on corruption. Moving now to the third and final legal issue, the manner in which corruption and bribery may be proven. Professor Bin Cheng put in his classic treatise on general principles of law that in cases where direct evidence of a fact is not available, it is a general principle of law that proof may be administered by means of circumstantial evidence. And the Metaltech Tribunal affirmed that corruption is by essence difficult to establish, and it is thus generally admitted that it can be shown through circumstantial evidence. And contrary to my colleague's statement, Metaltech is not the first tribunal, arbitral tribunal, that has found corruption on the basis of circumstantial evidence. Several ICC tribunals have refused to enforce claims by agents against their principal under services contracts because they found, based on circumstantial evidence, that the contract was in fact a contract of corruption that could not be enforced. The clandestine nature of corruption must be a paramount consideration in evaluating evidence of corruption. As I've already emphasized, direct evidence of corruption is very rare, and so for international arbitration not to become a safe haven for corruption, there cannot be, as Mr. Geering suggested, a bright line rule that corruption can only be found on the basis of direct evidence, and arbitral tribunals must be able to and have the courage to make a finding of corruption on the basis of circumstantial evidence. Now, in the context of corruption, such circumstantial evidence is often referred to as indicia or red flags of corruption. The Metal Tech Tribunal explained that the international community has established lists of indicators, sometimes called red flags, which, although worded differently, have essentially the same content. And for the purpose of the final part of my presentation, which is a discussion of the facts, I will refer to the red flag list published by the ICC in 2010 in its guidelines on agents, intermediaries, and other third parties. So let me now move to the facts and address the evidence. First, Mr. Porphyros was the college roommate and a lifetime best friend of the then president of Dystopia, Mr. Vader. A close personal relationship of the third party with a public official is consistently highlighted in the red flag lists, including in the ICC guidelines, and it was an important factor in the Metal Tech Tribunal's finding of corruption in relation to two of the so-called consultants in that case. Now, Claimant argued that it engaged Mr. Porphyros on the basis of his qualifications and emphasized that Mr. Porphyros has actual qualifications as a lobbyist. Respondent does not deny that, but the fact is, and I will come to that in more detail in a moment, that there is no evidence whatsoever in the record that Mr. Porphyros rendered any kind of lobbying services here. And that, members of the tribunal strongly suggest that he was engaged not because of his lobbying qualifications, but because of his friendship with President Vader. Secondly, another important red flag in the ICC guidelines is that the third party's commissioner fee seems disproportionate in relation to the services rendered. There are two elements to this red flag: the amount of the fee and the services rendered. As to the fee, Utopian Gas paid Mr. Porphyros a total of $5.2 million. That is a very significant amount of money. It is more than 10% of the total project cost of $50 million for the entire Matrix Gas project. And on the other hand, what services were rendered for that price, we don't know. Mr. Geering emphasized that contrary to the claimant in Metal Tech, this claimant did not change tack in its explanations. And that is true, but only because there was no tack to change here, as claimant in this case simply provided no explanations at all. Mr. Geering also pointed to the fact that claimant produced some documents, but none of these documents provide any explanation at all of what services Mr. Porphyros actually rendered. And when the tribunal, in its procedural order number 4, ordered claimant to produce evidence of the services actually rendered, claimant did not produce a single piece of paper. The 2008 strategy that Mr. Geering referred to envisioned a speaking event with a recognized economist at the University of Dystopia and a press campaign in Dystopia and the international press. Now, if these actions had actually been taken, there would be a paper trail. There is none. And claimant's witness evidence fares no better. Mr. Moore testified that he understands Mr. Porphyros to have implemented the strategy, but his understanding is based on nothing, as Mr. Moore also admits that he did not have a single discussion regarding concrete steps with Mr. Porphyros. The only thing Mr. Moore can offer is that Mr. Porphyros told him that he was working on negotiating the layers of complexity within the dystopian government machinery. Now, that statement is so vague and general that it is meaningless. And in fact, the word negotiating may well be a euphemism for corrupt payments. We are all in the service industry. We all know that in this industry, a $5.2 million payment without a paper trail is a fantasy, unless the services provided cannot see the light of day. There's also no proof whatsoever of the lobbying and public relation expenses for which claimant supposedly paid Mr. Porphyros $2 million. Unusual payment arrangements is another red flag in the ICC guidelines. Now, claimant referred, and Mr. Geering referred in his remarks to the opinion of Mr. Cicero that it is normal not to itemize and to provide receipts for lobbying and public relation expenses. Mr. Cicero has fled corruption and tax evasion charges in dystopia. It's quite ironic that claimant has called an individual in exile evading such charges to provide expert testimony on the propriety of the services contract. And given the pending charges against Mr. Cicero, there's also a serious question as to his impartiality, because he is quite likely to hold a personal grudge against the new regime. But the most important point was raised by the members of the tribunal themselves. Respondent called Mr. Cicero to testify. He did not appear. Mr. Geering gave an explanation on behalf of Mr. Cicero, but I would like to emphasize this explanation comes from claimant. There is no letter, no affidavit in the record from Mr. Cicero himself explaining why he did not appear. And so respondent submits that his report should be afforded no weight by the tribunal. Now, the only other explanation for the absence of any proof for the $2 million in supposed lobbying and public relation expenses came from Mr. Moore. He stated during cross-examination that he did not need to know the exact nature of the expenses. What this sounds like is that he did not want to know the exact nature of these expenses. Any responsible businessman needs to know the nature of expenses when he is asked to pay $2 million, unless, again, the expenses cannot see the light of day. Now, in the interest of time, I will just very briefly highlight three other red flags that are present in the case. Claimant paid $2 million as an upfront fee, more than a third of the total amount paid under the services contract. Such an advance payment not tied to any particular service is a red flag under the ICC guidelines and was also a factor in the Metal Tech Tribunal's finding of corruption. Second, the services contract provides for payments to be wired to a bank account held by ABC Services, an entity incorporated in Panama, the same month as when the services contract was entered into. All elements of this structure are red flags under the ICC guidelines. Payments to a shell company, different from the party to the contract, and located in an offshore jurisdiction. And thirdly, the services contract includes a non-disclosure clause that requires the parties to treat it as confidential and any information relating to it. Such confidentiality clauses, again, are a red flag in the ICC guidelines and were a factor in the Metal Tech Tribunal's finding of corruption. And finally, all of these red flags are compounded by a background of corruption in the country. Professor Bermann has already asked claimant about his submissions on this. Our submission on it is that it is absolutely more likely than not for corruption to occur in certain jurisdictions more than others. And consistently with that, the fact that the third party operates in a country known for corrupt payments is a red flag in any red flag list that you will look at, including that of the ICC guidelines. So to sum up, members of the tribunal, what we have is a $5.2 million payment to the best friend of the then president of Dystopia for the purpose of obtaining a matrix gas concession through a non-transparent corporate structure in Panama without any proof of services rendered and any proof of expenses incurred, all against the background of a corrupt regime. Now, there's no direct evidence of what exactly happened, what exactly Mr. Porphyros did with the $5.2 million that he received, because that has been concealed. But I submit to you that the faisceau d'indices in this case including claimant's complete inability to provide any credible explanation for the payment, leads to the inescapable conclusion that Mr. Porphyros used the money to bribe public officials in dystopia, and for this reason, respondents requests that you find on a similar record where there, like many arbitral tribunals before you, on a similar record where there was no direct evidence, but inescapable indirect evidence of corruption, that claimant engaged in corruption. And as a result, respondent further requests that you find that as bribery and corruption have been crimes in dystopia since 1989, claimant shareholding in Matrix Gas does not qualify as an investment for purposes of the bid, and this tribunal has no jurisdiction over claimant's claims. Thank you very much.
Thank you, Ms. Santens. Questions from my colleagues, for Ms. Santens, or
yes,
for
I have a
both?
question, if I
Yes,
may, and
please.
it will be a question to Mr. Gearing eventually as well. I'm accustomed, when I entertain the exercise of examining the totality of the circumstances, I'm accustomed to finding circumstances that point in different directions and my having to weigh them by some measure or another. Now, I would like to know, in the full interest of candor, whether there is any circumstance in this case that you think militates in favor of the proposition that a bribe was not paid. Put differently, is this, in your opinion, and Mr. Gearing, I'll be asking you this as well. In your opinion, is this a case in which no red flag is missing? I mean, I know you've mastered the red flag lists
Yes.
that are out there. So is this that archetypal case in which every indicator points in the same direction?
No, I will give you, there's one red flag that is missing here, and that is that the agent is not qualified to deliver the services for which the agent was engaged. And in our circumstances, Mr. Porphyros was a recognized lobbyist in dystopia, and so we don't deny that. What we say in response to that is what I already said, that because Mr. Porphyros is not shown to have delivered any lobbying service in this particular case, our submission is that he was not hired for that reason, but because he was the best friend of the president.
Thank you. Obviously, my question is premised on the notion that circumstantial evidence may be an adequate basis, and that circumstantial evidence should be looked at fully contextually.
Yes.
That's the premise of my question, and I take it that's the premise of your advocacy.
It is. Yes.
Thank you. Thank you, Mr. Chairman.
Questions? Any question in particular to the claimant? And then I think we will open the questions that are directed to both.
My questions are for both.
Yes, so why don't you start with...
Well, I'd like to thank the two advocates for helping the tribunal understand this issue. And for the purposes of this particular proceeding, I must say I still have questions about the burden of proof, which becomes very important in the case for the reason my colleague has described. In particular, if I go to claimant first, I'm troubled that on the one hand, your first point is this is serious, you believe it should be eradicated, and yet you set a high standard of proof, thereby giving us the task of allowing to decide whether it is so serious a matter, but yet allow it to go on. In your answer to my question, let me see if I can summarize your answer. You stated the burden of proof, despite its potential significance for the outcome, is a matter for the tribunal's discretion as a forum rather than the law of dystopia. Yeah. So, and I think that's correct, we do not decide as to the contract's validity. We are deciding whether there's a jurisdictional bar in this case. If this regime, this entire investment system, is an attempt to deal with something as serious as this, why is the burden high? What is this general consensus you're pointing to? And let me just add to that the second part, which is you point to the serious knock-on effects of such a finding. But actually, all we need find is that for the purposes of our definition of corruption, with a lower standard of proof, in this setting, there is a bar to jurisdiction. Yeah. There is no finding as to corruption per se under dystopia law. The chances of investigation already exist. Our finding itself does not increase those chances.
I think there are two, thank you for that, sir. There are two answers, as shortly as I can, to your question. First of all, yes, seriousness of the allegations is why a higher standard of proof should be applied, and particularly because what you're doing is not a mechanical exercise, it entails a moral judgment on what's gone on, and a moral judgment on the relevant individuals. And secondly, and Ms. Santens didn't deal with these at all, but the knock-on consequences, with respect, sir, I would differ. The knock-on consequences are very real. If you make a finding of corruption, it's very unlikely to end here. It is likely to act as the trigger, the spur for regulatory investigations elsewhere. It will provide possibly grist, or quite likely grist for the mill of the courts in the relevant state. It will also, as I said, very clearly, very likely ruin the careers of the relevant people.
Counsel, in earlier argument, you stressed to us that causation has not been established.
Yes.
In this. But now you allege it's our decision that will cause the investigation.
Well,
isn't that investigation already prompted? It is not our job to find there is no corruption in this case. At most, we find it's not proved to some standard.
Yes, I accept that. That is right. It's your job in this case to consider whether the applicable treaty standard has been met. But the reality is that your decision will be public, and your findings on the fact will be of relevance, I submit, in other fora, and may be taken as highly persuasive indicators of the position in other fora. Now, if I may just revert to a point you made at the start of your comments to the question, and this also echoes something Ms. Santens says. I meant what I said at the start, and my client very sincerely wanted me to say this, that we are, on this side of the table, very much against corruption. We don't endorse international arbitration tribunals becoming a safe harbor for corruption, which is what has been written in one or two articles. But that doesn't mean that you should, if I put it colloquially, you should run around finding corruption when you're not clear that it exists. And in that context, if I can just say something about the distinction between direct and circumstantial evidence. Now, Ms. Santens says Mr. Gearing requires direct evidence. I didn't say that. I don't go as far as that, and I was careful, or I tried to be careful not to go as far as that. I do accept, I said the relevant standard, my primary case was the relevant standard was clear and convincing evidence. In certain circumstances, you can take into account circumstantial evidence, but the circumstantial evidence has to be strong circumstantial evidence. And I won't take up time delving back into the facts here. You don't have that here. You don't, for example, let me give you one example. You don't have, for example, evidence that the relevant consultants entertained inappropriately officials or ministers of the relevant state, that they brought them to London for a lavish weekend of luxury, for example. Now, there might be a question as to whether or not a lavish weekend of luxury was a breach of the law of the relevant state. I don't enter into that question at the moment. But if that had taken place, that might be said to be a circumstantial factor that would then motivate an inquiry as to whether they had improperly or arguably improperly spent money in respect on government officials or given money to government officials in other respects. But you have nothing like that here. You don't have any red flags in that regard.
Thank you, counsel.
Should we ask
Yes.
Respondent, Ms. Santens, would you like to comment on what your opponent just said and answer Professor Caron's questions?
Well, in particular, could you reply to the argument that the seriousness of this charge, the tribunal has a special responsibility with that charge, and we need to think about, it is intended that we think about the consequences of such a finding of corruption, and therefore the burden should be high.
Yes, so on the seriousness of the charge, I heard Mr. Gearing say that you would be required to pass a moral judgment. I don't think that that is correct. You need to find whether there is corruption or not. There is no moral judgment involved in that. As to the consequences, Mr. Gearing alluded to potential regulatory investigations in dystopia. It is true that may be a consequence of a finding of this tribunal, but if such an investigation were to take place, it would take place on its own terms, with its own standard of proof and its own rules, and the finding of this tribunal would probably be irrelevant or certainly not have any kind of res judicata effect in such kind of proceeding. As I've already said in my remarks before, also, it hasn't been explained that a finding of corruption would be in any case, in any circumstances, be a more serious finding than a finding of unlawful expropriation, unfair and equitable treatment, discriminatory treatment. Those are all very serious allegations, serious charges, which give you a tremendous responsibility to decide. And in respondent submission, the seriousness of your task is no less or more when you have to decide those claims from claimant as compared to respondent's argument of corruption. Does that answer your questions?
Thank you.
Yes.
I have a question for you both as well. And I think you've impliedly answered my question. I think if you'd like to amplify your answer to my question, if indeed it was partly an answer about the absence of red flags, I would welcome that. But my question is the following. I'm still, after all of this discussion, I'm still thinking this is more a standard of proof than a burden of proof issue, although the label doesn't really matter that much. But I think it's what is the strength of the showing that is needed to be made, that is at the heart of this case, whatever label we attach to it. Now, we've been working with a very small handful of investor-state decisions, but by any measure, a small number from which we've tried to draw some inferences, even though we know we're not bound by them. That encourages me to think a little more broadly. And while recognizing the distinctiveness of investor-state arbitration, the problem we've been discussing today arises with vastly greater frequency outside this context. It arises in civil suits all the time. Claims of fraud or illegality, corruption, or various other vices in contract cases. There's an analogy here. And therefore, I would like to ask you both, and I'm assuming you've done some homework in this regard, if you were to expand your range of vision beyond the investor-state cases that we have, the scant number that we have, and looked at how how courts approach the standard of proof question when these explosive, very serious issues are raised in civil cases, and let's leave criminal off the table for obvious reasons, but in civil cases across the board, can you help enlighten this tribunal? Speaking for myself and not for my colleagues, I am prepared to be informed about the treatment of these kinds of issues in civil cases for the limited purpose of determining whether the quote or unquote seriousness of the issue alters the standard of proof that we should be applying to these cases. I'm a little bit uncomfortable with confining our inquiry to those investor state cases that happen to have addressed this question. I think the issue is the arguments that have been made, particularly by you, Mr. Gearing, the argument you made about seriousness and the implications of findings of this kind, they invite, I think that argument invites a much broader inquiry, a wider universe of cases. Now, can you help me out here? Either of you, maybe Mr. Gearing, you first.
We both cited to Lord Hoffmann. Now that was, as I said, that was a case concerning an appeal against a deportation. But it is fair to say that the English and English common law jurisdictions, to a greater or lesser extent, follow the approach set out by Lord Hoffmann, which is cogent evidence is required, but that's applied by reference to the balance of probabilities. And what I was saying to you is that even if you go down that route, practically speaking, you'd end up in the same or similar position as if you adopted the EDF and Romania clear and convincing evidence proof.
Let me ask you, if we had a simple garden variety contract case in which a defendant asserts that a signature was a forgery, would I, as a decision maker, require a higher standard of proof of forgery in this garden variety contract case, or would I be content with a preponderance of the evidence?
It would be a balance of probabilities, at least in the sort of the English and the English common law world. I'm probably slightly recklessly speaking. I know there's some eminent Australian jurists in the audience, but amongst the tribunal secretaries, but I do understand that to be the case. But it would depend. You would then require cogent evidence. I think that much is clear. And then it would depend. You would then ask yourself, well, how likely is this to have occurred? Is this something quite extraordinary that is being alleged, or is this something that is more usual? So that's how you would assess it, and that's consistently how English common law courts have approached it. As to the second point and the reference to red flags, without delving too deeply into the facts, again, but you did invite a brief response. Ms. Santens said, well, we do not know what services were rendered. Well, what she didn't tell you was that Mr. Porphyros, the one person who can really tell you, died in prison recently, and therefore we're not able to call him. We've called the one person we can call, Mr. Moore, and we've given you all the documents we have.
Thank you.
If I could address
you
Please.
would like to respond about Mr. Porphyros' death in prison?
I would first of all like to address the more theoretical question posed by Professor Bermann. First of all, I think it's important to remind you that whilst not that many investment treaty tribunals have addressed the question of the standard, many ICC tribunals have, and so I would commend to you that significant volume of case law. Now, many of these ICC decisions do look to national standards, of course, because they are commercial arbitrations, and so they're more tied to national law. So to come to your question on how national courts deal with this question, the important point is that no national court actually heightens the standard when addressing a question like this. In civil law cases, the standard is intime conviction, which is the same standard whether the tribunal, whether the court decides a breach of contract or a claim of fraud or any other kind of similar claim. In England, as we have both submitted to you, the courts specifically say that the standard should not be heightened. What is required is more cogent evidence, but that is not the same as requiring a higher standard. In fact, Lord Hoffman, in the opinion that Mr. Geering quoted to you, specifically says there is only one standard in civil cases, and that is the standard of preponderance of the evidence. And third, in the United States, where the clear and convincing standard originates, expression, I will say, originates from, this is not a higher standard either. The standard is the civil standard of a preponderance of the evidence. The courts just require more convincing evidence. What has happened is that a few of the investment arbitration tribunals that have accepted the standard, in my view, have accepted it as a higher standard, whereas the one jurisdiction where, to my knowledge, this expression originates from actually does not consider it a higher standard, but just an expression of what is very similar to Lord Hoffman's expression of more cogent evidence.
Thank you.
Thank you. So the tribunal would have many more questions because it's a fascinating topic, but we see that time is passing, and therefore, listening to you, frankly, the more I think about these standards, the more I feel maybe there's lots of semantics, and in the end, can you convince the tribunal or can you not? And that is the real question, and each of you has 2 minutes to now wrap up and convince the tribunal. Mr. Geering.
Well, I can maybe be even shorter than that, Madam President. The respondent's case amounts to an attempt to reverse the burden of proof. Ms. Santens more or less accepted in her comments that she, the respondent, bears the burden of proof. Her case is this. She says the investor cannot provide chapter and verse detail as to what its consultants were doing. Therefore, she says, the payments must have been bribes. And therefore, she says, the bribes therefore are illegal and they procured the investment. She makes an enormous leap. In circumstances where we cannot produce the senior consultant, Mr. Porfus, because he's dead. I won't get into the allegations surrounding the controversial circumstances in which he died, but it's common ground that we can't produce him. It's common ground that he's dead. That amounts to an attempt to reverse the burden of proof. And as I said right at the start of my submissions, that is to start to slide or slip down a slope, and that is a dangerous way to go. Investment treaty tribunals absolutely must find corruption where they see it, where they clearly discern it, but this is not one of those cases.
Thank you. Ms. Santens?
Yes. Respondent's position is not at all to request a reversal of the burden of proof. What respondent has asked you from the beginning and asks you again is that you consider the totality of the evidence before you. The international community has come up with a number of red flags. These lists are put together by experts who have seen corruption and know when corruption is present. Respondents admits that the facts in this case do not tick all the boxes. Not every red flag is present. I assume there are very few scenarios where that would be the case. In this case, we submit to you that the amount of red flags that are present, the cluster of evidence, is strong enough to lead to a conclusion, to a finding of corruption. $5.2 million was paid with no explanation whatsoever. Mr. Porphyris indeed is not present, but Mr. Moore was here, and there were documents that could have been provided. Mr. Moore was not able to give convincing explanations, and not a single document was provided. And so to us, the only logical conclusion that can be reached in this case, that that very significant amount of money was used to bribe public officials in dystopia. Thank you.
Thank you very much. This closes this hearing, not without the tribunal thanking the advocates for their very ably presented closing statements. And of course, we thank all the audience for having listened very patiently to this final hearing.